call the member for North Sydney.
Thank you. I move amendments 1 to 4 as circulated in my name together. Deputy Speaker, Australia's Privacy Act is not only outdated, it's simply not fit for purpose anymore, and it is fundamentally failing to keep up with the rapid rise of technologies that rely on vast quantities of personal information. But given the Act was introduced in 1988, prior to Australia even joining the global internet, and in the same year as the Brisbane Expo, I might add, here in Australia, espoused that by 1988 we would all be living lives of wonderful luxury because the internet will have helped us become obsolete, it's not surprising that this Act no longer works. Fast forward to today, and the reality is digital technologies are rapidly making all elements of this Act almost obsolete. Artificial intelligence has stretched beyond the confines of science fiction. Our biometric data is used by shopping centres for targeted advertising. Our social media photos are used to train AI. And our devices record and often share the details of our daily lives, our habits and our behaviours. I'm sure every single person in this room has had that experience where they will have a discussion with somebody that they love about something they might be considering purchasing or doing, only to then find when they go onto a social platform on their next iteration on their device, that option is sitting right in front of them amongst its advertising. Recent major data breaches have definitely raised public awareness and have further highlighted the need for wide-ranging reform of our privacy safeguards. According to the Office of the Australian Information Commissioner, just under half all Australians say they were affected by a data breach in the previous year, and 3/4 have experienced harm as a result of that breach. They report having their personal information stolen, being unable to unsubscribe from marketing communications, and having to provide sensitive information when they preferred not to. As a result, many are left feeling disempowered, stressed and anxious. The bill before us then is welcome, particularly the new civil penalties and the pathway towards establishing a children's online privacy code and the statutory tort for serious invasions. However, while the measures in the bill will strengthen Australia's privacy law, this modest legislation alone will not bring Australian privacy law into line with global best practice, and it is disappointing that the government has stopped short of truly modernising our privacy legislation. Ultimately, the Privacy Act Review report put forward 116 proposals for reform of Australia's privacy framework, of which the government has agreed or agreed in principle to 106. And yet this bill aims to implement just 23 of those proposals. And for this reason, I will continue to call on the government to introduce the second tranche of privacy reforms before the next federal election. But dealing with what we have here, among the many omissions in this bill is the absence of a fair and reasonable test for dealing with personal information. No requirement that entities take steps to mitigate harm to individuals following a data breach, no clarification of timeframes for notification of data breach, and no updated definitions of personal information or consent. Yet one of the most significant reforms that is included in this bill is the introduction of a statutory tort or a civil wrong that will allow Australians to sue for damages for serious invasions of privacy and enable courts to award damages, grant injunctions and make a range of other orders. And while I do think this is a good development, I am concerned that the proposed exemptions are unnecessarily broad. Specifically, the bill introduces new and broad exemptions for journalists, enforcement bodies and intelligence agencies that deviate from the model proposed by the Australian Law Reform Commission and endorsed by the Privacy Act Review. The journalism exemption would exclude any acts ostensibly done while developing journalistic material and would apply regardless of the content or the purpose of the journalism. This would mean that blatantly illegal and unjustifiable infringements of privacy by journalists that are not in the public interest would be exempt from the right of action. This might include illegal phone hacking by a news corporation or upskirting photos taken of celebrities by a tabloid. And I can't help but think many people would rightly expect that this is precisely the type of infringement that this tort should apply to. Serious infringements of privacy without a principled justification. In addition, the exemptions for enforcement bodies and intelligence agencies are unjustifiably broad, in my opinion, given there is a separate defence already for invasions of privacy that are required or authorised by law that would already cover lawful government interference with privacy. The detailed amendments I'm moving today then would narrow the journalism exemptions to apply to public interest journalism and better clarify the application of the enforcement bodies and National Security Agency exemptions. And I commend the amendments to the government.
The question is that the amendments be agreed to. I call the Attorney-General.
Thank you very much, Deputy Speaker. The government does not support the amendments that have been moved by the member for North Sydney, but I am grateful for the support that the member for North Sydney has expressed for the bill itself. The government has given careful consideration to the breadth of the proposed exemptions and defences to ensure that protection of privacy is appropriately balanced with other legitimate activities. The defence for conduct authorised by law would apply to conduct that is expressly authorised or impliedly authorised where the conduct is clearly necessary to carry out an activity authorised under statute. This is consistent with a similar exception to a number of the Australian privacy principles. Exempting all journalistic material from the tort will protect the free flow of information to the public through the media. Seeking to confine the exemption to material that is in the public interest would lead to arguments about the merits of publications and would only serve to increase the length and expense of court proceedings. The exemptions for enforcement bodies and intelligence agencies are intended to ensure that these entities are not unduly restricted in carrying out their legitimate functions. It recognises that in some instances these may need to be privacy intrusive. These agencies do have their own oversight processes and mechanisms that regulate their conduct, which are designed to suit their operating environment.
The question is that the amendments be agreed to. I call the member for North Sydney.
Thank you, and thank you for your response, Attorney-General. Can I just ask then a clarifying point? So, to your commentary just then, this bill does introduce broad exemptions for journalism that could potentially, I'm concerned, it will potentially cover unjustifiable infringements like upskirting, which is where a photographer will take a photo of a celebrity with the camera going directly up underneath their clothing, or even phone hacking, which we saw in the not too distant past, specifically in the UK. Can you please confirm whether, under the current bill, these activities would be exempt?
The question is that the amendments be agreed to. Call the member.
Raised by the member for North Sydney, I can say that this bill introduces what will be a new tort to Australian law for serious invasions of privacy. As with the development of other parts of tort law, we will see, as proceedings are brought, what the courts choose to describe as the full extent of the tort and the civil wrong that's being created by this legislation, and the extent of the defences. I'm not going to predict in advance exactly what the parameters of this tort are going to be. That's going to be a matter for case law to work through.
The question is that the amendments be agreed to. I'll put the question. All those of that opinion say aye. To the contrary, no.
Aye.
No.
Okay, as the question is unresolved in accordance with Standing Order 188, the question will be included in the Federation Chamber's report to the House on